Hi, Tom Mathers, here, special appearance, reserve all rights, and without prejudice.
Thank you, Mr. Mathers. And for the record, this is case number 26T16, People of the State of Colorado versus Thomas Mathers. Mr. Mathers is here in person. Ms. Marsh is here in person on behalf of the people. We are scheduled for a plea hearing today. I know that you had spoken with the district attorney previously and were thinking about getting an attorney. Could you give me an update on that?
I was actually asked some questions.
Sure.
In the court. The way I understand it is the Constitution grants 2 criminal jurisdictions for us to proceed with, and one being a criminal jurisdiction in common law, and the other one being a term of contracts in admiralty jurisdiction. And I was just wondering which one we are going forth with, or what are the rules of this court is what I'm looking for.
So the jurisdiction of this court is established by the Constitution, as you mentioned, but also by statute, which is a little bit different from the common law, and it's also not a contract. It is pursuant to the statutes of the state of Colorado, which give this court jurisdiction.
So it's statutes.
Correct.
Jurisdiction?
Yeah, statutory. Yep.
Statutory jurisdiction. Where could I find that? Where's the rules and regulations to this?
So they're not rules or regulations, they're statutes, but you can find them in the Colorado Revised Statutes. If you search in those statutes essentially for jurisdiction, you should be able to find them.
So statutory, I don't have a pen to say.
There should be a pen there.
Statutory jurisdiction, you say?
Yeah, the statute itself is 136106.
106?
Yep, that's at least one of them. The 136106 would be one of those.
Just one of them? I mean, so there's more than one, I'm guessing is what I'm getting at.
Yeah, so the Constitution also grants jurisdiction, but 136106 specifically is regard to the criminal jurisdiction of the county court.
What was that again?
It's specifically regarding the criminal jurisdiction of the county court.
So this is it's not municipal then, is what?
Correct, it's not municipal.
Well, I guess I would ask time to research that.
So you want another court date?
Yes, if.
Any objection, Ms. Marsh?
None, Judge.
All right, I'll give you another court date here. And before I give you a new court date, this is just for scheduling purposes, this question. Do you still intend to get an attorney on board in your case, or you don't think?
I'm looking for one, yes. I'm not certain.
Okay, do you think it's going to be a private attorney or the public defender?
I was thinking private.
Okay,
But
thank you for that clarification. I'm not going to hold you to that. I'm only asking that for scheduling purposes. Can you come back on Friday, May 29th at 9:30 a.m.?
May 29th at 9:30?
9:30 a.m. Is that okay?
May 29th, yeah.
Okay, is that okay for the people?
That's fine, Judge.
All right, May 29th at 9:30 a.m. then is your next court date, Mr. Mathers. And again, I'll ask you for an update about if you're going to get an attorney, but you can just give me an update on that day. If you decide something different, I'm not going to hold you.
Or he'll, yeah.
All right, that'll conclude your case then, Mr. Mathers. Have a great rest of your day.
Yes.
And Mr. Mathers, if you'd come on up.
Hi, Tom Mathers, living man and beneficiary, here by special appearance, here to resolve this matter. I reserve all rights and waive none.
Thank you. The court calls case number 26T16, People of the State of Colorado versus Thomas Mathers. Mr. Mathers is here in person. We are on the record. Ms. Marsh is here in person on behalf of the people. We are scheduled for a plea hearing today. Last Friday, when Mr. Mathers was here last, the power went out, so we had to reschedule the case to today. so that we could actually make sure we were having a recording. I think before then, Mr. Mathers, you had told me that you were possibly working on retaining private counsel as well as doing some additional research. Could you give me an update on that?
I have questions to, I have some questions I'd like answered before, I guess.
Sure. You can ask them, and I may or may not be able to answer them, but I will do my best.
So if we go further, we go a bench trial, or we got two options, right? A bench trial or a trial by jury of my peers.
Correct. Yep.
And that's how many peers? How many?
6.
6. And that's peers that I pick, or I guess.
So I'm going to sort of generally describe it. Basically, what happens is we have a pool of jurors who are available in the county.
Yeah.
Those jurors are picked randomly from that pool. A letter basically is sent out to them that says you have to appear for jury duty. I'm not sure how many we usually summon on misdemeanors. Do you remember off the top of your head? It's somewhere around 80, right? It's so 80 people. They come in to the courtroom, so it's not specifically picked that initial pool by anybody in particular. It's just randomized. Then on the day of the jury trial, we put 12 folks into the jury box. Sort of initially, you and Ms. Marsh would both have an opportunity to ask them questions. At the end of that period, let's say, just assuming it's the same 12 people, you'll have an opportunity to strike 3 of them for any reason. Ms. Marsh will have an opportunity to strike 3 of them for any reason. And then whichever ones the 2 of you didn't get rid of, those 6 would be the remaining jurors.
All right. What definition of peers are we using? I mean, like, I understand that there's many different definitions of peers. What are we using, the Black's law, or something that is cited in the what am I trying to say? The CRS, or in the definitions of CRS.
So I don't think there's a specific definition that's being used here. It really is just we send out the summons to individuals in the county who qualify for jury duty.
Okay. And so if I don't enter a plea, you say you'll enter one for me?
Well, so it depends. I can enter one for you if, for example, the case is going on for a long time and nothing's getting done. And part of that is to protect your rights because we don't want the case to go on forever. But also everyone else has the requirement or, right to have this resolved expeditiously. I think at the last hearing, maybe not the last hearing, maybe back in April, I may have said that I would enter a not guilty plea on your behalf. That is a possibility. It is something that I can do and set the case for trial. So that is possible.
So if you do that, what trial do you set it for? I mean, is that a bench trial or a jury trial?
I would give you the option, whichever one you preferred.
And that's with you entering the plea?
Correct, yeah.
Is that
And to be very clear, the plea that I would enter is a not guilty plea. I would never enter a guilty plea on your behalf. I would never do that.
I didn't. I thought that was, I expected the opposite out of my.
Okay, it would be a not guilty plea, yeah.
So let me get this right. You tell me I can remain silent, but then you demand a plea out of me. I don't understand that, and isn't entering a plea from the bench, isn't that illegal? And I mean, I moved to dismiss this on jurisdictional, personal jurisdiction, because that's personal jurisdiction. I moved to dismiss this on personal jurisdiction.
Give me 1 second. I'll answer part of that. just to begin with, and then I'll take 1 second here to answer the personal jurisdiction question. You do have the right to remain silent. That right to remain silent is primarily to protect you from making any statements that are incriminating. When I ask you if you're going to enter a plea or I enter a plea on your behalf, particularly if the answer is not guilty, you're not admitting any fault. So it's not incriminating for you to say, I'm not guilty, and then set your case for a trial. So some questions I have to ask you, for example, to make sure you understand certain things, but I'm never going to ask you to talk about the facts of your case specifically. Unless you want to do that, I'm not going to force you to enter a guilty plea. The only thing that I would do is enter a not guilty plea on your behalf, which is you still saying that you're not guilty, that you didn't commit the crime or whatever the case may be. So that's not specifically incriminating. Give me 1 second on the jurisdictional issue. Right. As for the jurisdictional issue, which I think you said personal jurisdiction, is that correct?
Yes.
Okay. I do have personal jurisdiction in this matter. It is a case that is alleged to have occurred in Moffat County, Colorado. It was initiated by a summons and complaint that was filed with the court on January 26th of 2026. It was signed by you on that day. The Deputy Pogline did issue that. Looks like may have signed it on the 20.
It's illegible.
The date is a little bit difficult.
It's all. I mean, even the what am I trying to say? The charges.
The charges.
None of them are. I mean, it's 137. It looks like instead of 132. I don't know. I'm not here to argue that.
Sure.
I'm here to.
So I can read the charges on it. One is speeding 10 to 19 miles per hour over the limit. The other is drove a vehicle other than one equipped with an approved interlock device. So
and the numbers they're not even correct.
42-4-1101 is correct for speeding.
Yeah, okay, that one maybe.
42-132.5. Let me look at that one. That's 10A. And that one also is correct if it's 42-132.5, which I think that it is.
Read that one. I mean, if you.
So I think that.
I still
Sure.
ask you to dismiss this on personal jurisdiction. This is, I don't understand how you can take a victimless crime, pardon me.
That's fine.
And turn it into a crime by entering a plea for me and making me the victim of the crime. I do not understand that.
Sure.
I mean,
So
this
I
is a
haven't.
victimless crime. I haven't hurt nobody, damaged no property. And you want to turn me into the victim of, I don't understand how you can do that when you ask me to, you read me my rights, offer me the right, and then tell me that I can't, that it's not legal option for me to take pretty much, that you're going to enter a plea and from the bench illegally, I guess, is the way I read it. And I ask for this to be dismissed.
Right. I'm going to deny your motion to dismiss based on personal jurisdiction, as I mentioned about the summons, which was served on you. You did sign that summons as well.
Your Honor, did
I'm
you
not-
see how I signed it? Under duress?
I don't see anything indicating that it was signed under duress, but also
What UD meaning?
UD. I see. Still, you did receive it. The issue
Under
that
duress, it was that or go to jail.
I understand that you may not agree with the summons, but you did receive a copy of it. I do have personal jurisdiction in this case based on that. Ms. Marsh, and I'm going to come back to this in just a second. Ms. Marsh, are you objecting to another continuance in this case?
I am.
Judge, at this point, I would be. We're almost 3-4 months in on something that is fairly standard and could have been resolved months ago.
So you have some options today, Mr. Mathers. I'm going to give you the options and you can decide what you want to do. Well, I should ask you this instead. So you do have some options. Those options include that you can plead guilty. I don't know if there's an offer in this case. You could potentially accept that offer if there was an offer. You could plead not guilty and set your case for trial. Or you can ask to do something else, and I would consider that. I'm not going to say I'm going to grant it one way or the other because I don't know what your request is. What are you requesting to do today?
I request this be dismissed on personal jurisdiction because of the fact that if I don't enter a plea, you're going to enter a plea for me, and it's against the law, I believe, for you to enter a plea from the bench. I mean, the way I read it, it's only supposed to be a lawyer or me that enters my plea. And if I'm wrong there, please correct me.
All right. Well, I'm going to deny your motion to dismiss, and I haven't entered a plea for you one way or the other.
But you plan to. I mean,
I might. That's true. Are you not wanting to enter a plea today, either guilty or not guilty?
I asked for this to be dismissed. That's where I stand.
Okay. And I'm not going to dismiss the case based on that. So given that the case is not being dismissed, what do you want to do with it?
I guess I plead the fifth then.
Okay. So pleading the fifth specifically relates to, not answering an incriminating question. I'm not asking you to incriminate yourself. I'm asking you if you want to
What
plead.
is the plea then?
You want to plead?
No, I said, what is a plea then?
What is a plea?
I mean, should we go through the definition of that too? Because the way I understand, I mean, you're not, what did you just say to me?
So
Forcing me?
I'm not forcing you to do anything. My question for you is, at this time, do you wish to enter a plea of not guilty and set your case for trial? Or what else would you like to do with your case?
I stand on dismissal. I do not wish to continue here. I don't understand how you can tell me I can remain silent and then tell me I have to make a plea. It
Well, you don't
doesn't
have
make
to.
no sense to me.
You don't have to plead guilty. If you plead not guilty, you're not incriminating yourself.
I don't plan on entering a plea until I understand that.
Okay. So I'm going to go ahead and quote to Colorado Revised Statutes here, specifically CRS 16-7-208. That is under Title 16 related to the rules of criminal procedure. It says as follows: if a defendant refuses to plead, or if the court refuses to accept a plea of guilty or a plea of nolo contendere, aka no contest, or if a corporation fails to appear, the court shall enter a plea of not guilty. If for any reason a plea has not been entered, the case shall for all purposes be considered as one in which a plea of not guilty has been entered. So I am required, if you're not going to enter a plea, to enter a plea of not guilty on your behalf pursuant to that statute.
Is that not a crime, entering a plea for me?
Not if it's a plea of not guilty, it is not a crime.
That is, I mean, the only people that are supposed to enter pleas are lawyers. I've heard is what I read. Are you a lawyer? Are you?
I am a lawyer, yes.
So
I'm not your lawyer.
You're not supposed to be practicing right now, right? Is that the way I understand it?
So I'm not your attorney, and I don't represent anyone at this time, but I am still an attorney licensed in the state of Colorado.
Pardon me, this is a question I should ask earlier.
That's okay.
Are you not defending me in a sense too? I mean, you do want justice, right? I mean, you do not, I mean, you're guardian over this court to produce justice, not injustice or, right?
Sure.
So you're, in a sense, you're watching over me too, right? That I don't get taken advantage of.
Right, but I'm not a defense attorney, and I'm not your attorney, and I don't represent you.
You manage justice in this court.
Sure, and it's my role to protect the rights of both sides in a case.
Yeah, so that's what I'm saying. Yeah, so you're kind of defending both of us, right? I mean, you're neutral, I guess.
I would say neutral.
Arguing.
I wouldn't say that I'm defending either side. I would say neutral. Yeah.
I still stand where I stand. Plan to move to dismiss this on personal jurisdiction on the facts that if this victimless crime, if I don't enter a plea, you take it and make me a victim of.
I'm not making you a victim of any crime. There is no crime, and in fact, I am required if you don't enter a plea.
Is this a
to
criminal
enter a
court?
plea on your
Is
behalf.
this a criminal court?
Yes.
There's no crime, you said?
I'm not committing a crime against you or making you a victim of a crime. You're alleged to have committed
So
the two
you're not,
crimes.
you're not,
You're alleged to have committed the 2 crimes that we went over earlier pursuant to that summons and complaint. And those are allegations at this point. You haven't been found guilty or not guilty, but that's what you're alleged to have done.
Judge, if I could just hop in here real quick, I think at this point it'd be prudent for me to make a fry record for the offer.
Sure, go ahead.
And this offer was extended to Mr. Mathers back on April or March 25th. It was to have him plead guilty to count 1, evading interlock, with dismissal of count 2, the speeding, and the only sanction would be the minimum fines.
Do you know what the minimum fine is?
Let me pull up my sheet and then I can tell you. It looks like it's a $300 fine, Judge.
$300. Right. Do you understand that that's the offer in your case, Mr. Mathers?
Your Honor, I have got another question.
Sure.
Is it not double jeopardy when I stand in front of this court and get charges, and immediately after this, I gotta go to the DMV and hold another hearing? Isn't that not double jeopardy?
It's not double jeopardy because
How?
the DMV doesn't handle criminal charges. They handle a separate process regarding the privilege to drive.
So it's still the same action.
I don't.
I'm being held for one thing in 2 different courts. It's double jeopardy, is it not?
I don't believe that it would be double jeopardy. Certainly, certainly, I'm just going to offer this, is that if you set your case for trial, you're going to have an opportunity to file motions. I think I would need to know a little bit more about that before I really can answer the question and make a final determination. That's a motion you could file, and I would consider that. But right now, I don't know that I have enough information to say.
It's something that's done 100 times, right? Doesn't the Chevron difference, doesn't that heavily affect this too, being that, the courts rely on them for decision making, like what am I trying to say? A standard?
So they handle a different process than we do.
What are you talking about?
So they handle the process about, the DMV, I'm sorry. The DMV handles the process, and this is just my understanding, right? I'm not involved in that process. They handle a process that's separate from this that I'm not involved in, so I really can't say exactly what the DMV is doing. But my understanding, and this is not legal advice, is that it's related to the privilege to drive and your license. I and the courts are not involved in that process. At least this court's not involved in that process. I don't participate in any way there. My concern here is specifically related only to the allegations contained in the complaint and information, and resolving that issue, at least in terms of what we're here for today.
May I offer the courts a plea bargain? Is that one?
You wouldn't offer it to me, you would offer it to the district attorney. But if you'd like to have an opportunity to talk to her right now, I'm happy to give you that opportunity.
Your Honor, I still don't really understand how you can offer me my rights to remain silent and then in the next sentence order me to make a plea. That does not make sense to me. It's my right.
I agree that
my
you
right.
have the right
You
to remain
told
silent.
me that, and then you tell me I can't. I don't understand this.
So I agree you have the right to remain silent. But if you don't want to make a plea because you're worried that might incriminate you or violate your rights, then as I mentioned, pursuant to that statute 16-7-208, I am then required to enter a plea on your behalf, and that plea is a plea of not guilty. So If you don't want to answer the question of what you're going to plead, then I will enter a plea of not guilty on your behalf pursuant to that statute.
And that's practicing law from the bench.
Well, I'm not so sure about that. It's simply following statute
That's
and what
the
I'm
way
required
I
to do.
read it.
Okay. But that's what I'm required to do if you don't want to enter a plea either way today. So you just need to tell me if you're not willing to do that, I will enter a plea of not guilty on your behalf. Because that's what I'm required to do.
I reinforce my right to remain silent.
Okay. And that's just fine. I am going to enter a plea of not guilty on your behalf pursuant to statute 16-7-208. That means I am going to set this for a trial. Would you like to have a jury trial or a trial to the court, Mr. Mathers?
16-7-208, is that what you said?
That's correct, yes.
CRS?
Yes. Would you like to have a jury trial or a trial to the court?
Jury trial.
Okay. There will be to a jury of 6.
I retract that off the record. I don't, I'm still at the 5th. I plead the 5th.
Okay. I am going to set this for a jury trial. It will be for a jury of 6. Let me look for a trial date. The first day that I have available for a trial date is October 8th. That is a Thursday. It's October 8th, not October 6th.
October 8th, you said?
October 8th, yep. Are you available on that day?
What day? Is it the day of the week?
It's a Thursday.
I'm sure I can make that work.
Okay, October 8th. So that will start at 8 a.m. It will be for one day. I'll expect everybody to be here at 8:15 at the latest on that day. Ms. Marsh, do the people need, sorry, go ahead if you have a
You
question.
said 8 and then 8:15, so we'll just,
So it starts at 8, but basically I give you a 15-minute window to get here. Ms. Marsh, do the people need time to file any additional charges?
No, Judge.
Okay, the people will not file any additional charges in this case. All right, we always set a motions deadline and a motions hearing. So for example, if you wanted to file that motion regarding double jeopardy, you can do that by this next deadline that I'm going to tell you here in just a second. If either party could have any substantive motions or pretrial notices filed by Friday, June 26th, that will be the deadline.
that's for all evidence.
So that's specifically for any pretrial motions or notices. So for example, anything related to Miranda.
So yeah, pre-trial will be before the trial, right?
Yeah,
So
exactly.
we don't have one of them arranged yet. If I get some paperwork in by then we will have one of those.
Yeah, so I'm actually going to set another hearing besides the trial right now. I'm actually going to set 2 more. One of them is going to be a motions hearing to address any motions that you file. One of them will
So
be
the 8th is trial.
the 8th of October is the trial date. Yep. The motions deadline, as I just mentioned, is going to be June 26th. Any responses to those motions will be due by July 10th. And any
What was that?
replies,
Any replies to those motions was July?
yeah, responses are July 10th. And then replies to those responses, if there are any, will be due on July 17th. We'll go ahead and we'll set a motions hearing. That way, if we need to address any motions, we can take care of that. Why don't we go ahead and set a motions hearing for Friday, August 21st at 1 p.m., if that would work for everyone.
August, what was that?
21st,
21st at 1 p.m.?
1 p.m., and that's a Friday. Would that work for the people?
1 second. We can accept that date, Judge.
Okay. So that'll be for that. We'll go ahead and we'll also set a pre-trial readiness conference. So that'll be separate from the motions hearing. It'll be before the trial. Can you all come back for that pre-trial conference on Friday, September 25th at 11 a.m.?
What was that called again?
Pre-trial readiness conference.
How long is the motions here?
Set it for 1 hour. Thank you.
We said September 25th.
Yes.
We can accept that date, Judge.
Thank you. All right, so I've got a couple of more deadlines that I'm going to set. There's going to be a separate deadline for what we call motions in limine. Usually those are related to, for example, evidentiary issues that may come up at the trial. In limine, IN space LIMINE. That's Latin for at the threshold. That due date for motions in limine will be due on September 18th. So 1 week before the pretrial conference.
What was that before December or September 18th? Is that what you said?
Yeah, September 18th. I will also ask that the people file any stipulated or proposed jury instructions no later than 7 calendar days before the trial. Mr. Mathers, if you wish to file any opposition to those or your own jury instructions that you'd like me to consider, I'd ask that you file those 3 days before the trial. I'll order all parties to comply with their disclosure obligations under the Criminal Rules of Procedure Rule 16, including any expert witnesses which shall be disclosed no later than 35 days before trial. I will accept any plea agreement up to and including the pretrial readiness conference, which is that September 25th date. And I'll ask that any final witness lists, if there are any, be exchanged by the pretrial conference. Ms. Marsh, did I miss anything from your perspective there?
Don't think you did. I think I missed the motions in lim date.
September 18th.
September 18th. Perfect. Then I think I'm good, Judge. Thank you.
Mr. Mathers, do you have any questions about any of that?
No questions.
All right. Then that will otherwise conclude your case today. The next time that you need to be here in court in person is on that August 21st date for the motions hearing. And otherwise, if you have any motions to file, please file them by that June 26th date, okay?
By the June 26th, file the motions,
Yes, if you have any.
and then August is the time when we discuss them or whatever.
Correct, yep.
All right.
Right, that will conclude your case today, Mr. Mathers. Have a good rest of your day.
Thank you.
Thank you.